Welcome everyone on Unacademy IAS Champion platform. You know that recently the Kolkata doctor was raped and murdered, which shook the conscience of the entire nation. This reflected a basic problem of not only Indian society, but a problem which every country is facing, which is the sexual violence against women. Women are still struggling to live a life of dignity, a life worth living. They are fighting for their autonomy, their respect, and coexistence with other species on this particular earth. So, in this context, in this session, we are going to discuss about the sexual violence against women. But very precisely, we are going to talk about the marital rape controversy. Because you know that recently a lot of PIL has been filed before the Honorable Supreme Court. And in this course of hearing, which is happening in the Supreme Court, surprisingly, the union government has defended that marital rape should not be considered as a rape. So, in this context, we will try to understand what are the merit and what are the demerits for such an exception. But before going and understanding the marital rape, let me highlight some of the important facts which shows that sexual violence against women is a harsh reality which we are encountering every day. You can see this particular image, very recent Kolkata protest. The doctors have come on the street and the entire nation was in a state of shock, primarily because of the heinous offense which was committed to a young doctor. Now, let us try to understand this entire story of sexual violence against women in terms of some facts. A woman becomes a victim of acid attack every 2.3 days. A woman becomes a victim of dowry death every 1 hour 13 minutes. A woman becomes a victim of gang rape and murder every 1 day and 6 hours. A woman becomes a victim of rape every 16 minutes. Now just imagine, I'm recording this session for around 10 to 16 minutes. And in this midst of 16 minutes, one woman have been raped in any part of India. If you see the government's official data of NCRB, you can see a constant spike in the sexual violence cases against women. It started with 3,71,503 in the year 2020. And now it has increased to a whooping 4,45,256 rape cases or sexual violence cases against women. Every hour, 51 cases of sexual violence against women are reported. And this specific problem is not limited to any part of India. You can see states like Maharashtra, which has a relatively high per capita income and a good rate of literacy, compared to states like Bihar, then you can see that Maharashtra has even a higher cases of sexual violence against women, which primarily denotes that sexual violence of women is not an exception in any part of India, but it is a norm which you can see in the entire part of India. So that's why we have to understand that the very, very fundamental structure of our society is based on the violence against women. Now, but in this particular session, I'm confining this entire debate of sexual violence, is this entire topic of sexual violence against women, to another controversial thing, which is the marital rape. You can understand by this particular photo where a husband says that now that I have married you, I can rape you without any consequences. And yes, he is right. Because in India, if a husband rapes her wife, if a husband does sex without the consent of her wife, then that kind of sexual intercourse will not be eligible for the definition of rape under the erstwhile Indian Penal Code and the newly enacted Bharatiya Nyaya Sanhita. Because in both of these codes, there is no concept of marital rape. Rather, it is explicitly mentioned that marital rape is not a rape. Hence, any husband which does kind of this particular act will not be subjected to the criminal proceedings which is there under the rape. So this we are going to discuss about in this particular session. But before moving ahead, Unacademy IAS fourth offline branch has opened in Patna, where our batches are starting. In New Delhi, Karol Bagh, in English medium batches are starting on 24th October. In Mukherjee Nagar, Hindi medium batches are starting on 21st October. And in Prayagraj, Hindi and English, both batches in offline medium are starting on these particular specific dates. You already know that Unacademy IAS does not only offer comprehensive GS course, but also CSAT, essay writing, comprehensive current affairs, full-length test series, and optional related courses. You can also interact with our educators, but for all these informations, you have to visit our Unacademy IAS offline branch, or you can download our Unacademy IAS app, where you will be getting all these sorts of information. Now, this is what I was trying to say before, that marital rape is not considered as a rape. And what do you mean by marital rape? Marital rape simply means that if in a marriage, a husband does sexual intercourse with her wife without her consent, even if she says no, but still if the husband does sexual intercourse with her wife, that will not be considered as rape, because if you see the erstwhile Indian Penal Code, in Indian Penal Code, you have a section 375 which deals with the rape. But in section 375, it has already been mentioned that marital rape is an exception to section 375, which means whatever discussion about rape we are having in section 375, marital rape will not be coming under 375. Similarly, in the newly enacted BNS Bharatiya Nyaya Sanhita, section 63 clause 2 talks about this particular exception. Only thing in India what we have related to marital rape is discussed in the Domestic Violence Act of 2005, and then there are some other provisions related to sexual violence against women in the Bharatiya Nyaya Sanhita. So if such kind of non-consensual sex happens in a marriage, you cannot take the course of Bharatiya Nyaya Sanhita's rape provision. Rather, you can approach the court under the Domestic Violence Act. So what are the limitations of Domestic Violence Act? Why Domestic Violence Act is not capable of protecting marital rape? This we will discuss later. But as of now, you have to understand that marital rape in India is not considered as rape. The only help which a woman can get is that woman can apply or initiate proceeding against her husband under the Domestic Violence Act of 2005. Now, what is the current status? 1 in 25 women have faced sexual violence from their husband. 1 in 25 women. And this is as per the government survey. And you know that these are the official survey. Many women do not speak. Women are silent. So this data will be much more worse if women starts to speak. That's what happened under the #MeToo movement. If you think about global, then marital rape is considered a rape in more than 100 countries. In fact, Britain, which introduced this exception of marital rape in India, Britain, they themselves criminalized marital rape in 1991. So as of now, only 25 to 30 countries are such which does not consider marital rape as a rape, which includes countries like India, along with Pakistan, Afghanistan, and Saudi Arabia, which still considers marital rape as an exception to rape in the statute books, means in the law books. So what has been the current controversy? The current thing what has happened is that there are the clutch of so many public interest litigations have been filed before the Honorable Supreme Court, where these kind of petitions wanted to criminalize the marital rape. So this case has now went to the Supreme Court. And in this context, the Supreme Court has asked the opinion of the government, that what the government of the day, the union government, thinks about it. So let us try to understand what the union government has said. So the union government has defended it. The union government has defended this exception. The union government has said that yes, marital rape should not be considered as rape. Why? What are the arguments of the union government? Let us try to declutter it. So the first argument which the union government gives, it says that the government thinks that the husband has no fundamental right to do a sexual intercourse with her wife without the consent, which means a husband cannot have sex, does not have a fundamental right of doing this without the consent of the wife. But considering this act as a rape will be too harsh and disproportionate. इसका मतलब कि गवर्नमेंट ये कहना चाह रहा है कि कोई भी हस्बैंड के पास ये फंडामेंटल राइट नहीं है कि वो अपने वाइफ के कंसेंट को वायलेट करे, बट अगर वो करता भी है तो आप इसको रेप से कनेक्ट नहीं कर सकते हो, बिकॉज रेप इज ऑल टुगेदर अ डिफरेंट थिंग. That's why considering this particular activity as a rape will be too harsh and disproportionate. And that is why government says that instead of considering marital rape as a rape, what a woman should do, that there are already many laws in India which protects women against sexual violence, which simply government wants to say, why do you need to initiate rape proceedings against the husband if a woman or a wife is not happy, if a woman or a wife wants to take action against the husband for this act, then she should not initiate rape proceedings. Rather, she should initiate the proceedings under the Domestic Violence Act. And the problem is, which I will come discuss later, so that's what the government has said, कि रेप कंसिडर करना ये सही नहीं होगा, ये बहुत हार्श हो जाएगा, ये डिसप्रोपोर्शनेट है, मतलब इतना बड़ा स्टेप नहीं लिया जा सकता है. बट गवर्नमेंट का कहना है कि कंसेंट वाइफ का लेना जरूरी है, बट अगर आप नहीं लोगे तो आप इसको रेप भी नहीं मान सकते. What next the government says? The government says that treating marital rape as a rape may impact the conjugal relationship, which can lead to disturbances in the institution of marriage. The government says that marriage is a sacred relationship. And if you bring the complexity of law inside the process of marriage, then it will lead to disintegration in the institution of marriage. So the government says कि एक हस्बैंड ने अगर वाइफ से कंसेंट नहीं लिया है तो वो इनका पर्सनल मैटर है, उसमें लॉ लाके उस चीज को और कॉम्प्लेक्स नहीं करना चाहिए, सो दैट जो एक सेक्रेड रिलेशनशिप है मैरिज का वो और खराब हो. So government does not want to bring law within the public confines of a husband and a wife. Fourth argument, government का कहना है कि it does not violate Article 14 because the petitioner said कि एक तरफ एक लड़का if he is having a sexual intercourse with a girl without her consent, आप उसको तो रेप मान रहे हो, but if a husband is doing the same thing with her wife, then you're not considering it as a rape. This is a violation of Article 14 because Article 14 basically talks about the right to equality. So the government says that it does not violate Article 14 because Article 14, if you have read Article 14, it talks about equality before law and equal protection of law, which means government can give special preferential treatment to different classes of people. So Article 14 is about equality among equals. It is not about equality among unequals. So you cannot treat Ambani and you can treat a rickshaw puller in the same way. You have to give different protection to a rickshaw puller and a different protection to Ambani because they are not equals. That's why the government says that considering a boy having a sex with a girl without her consent, that is a different class, that is a different set of game altogether. And a husband and a wife, when then they are in a sacred kind of a relationship of a marriage, that is a different class. Because, for example, you are in a relationship, you cannot expect to have sex with your girlfriend or a boyfriend. But if you are in a marriage, then in marriage, you have to have an expectation of fulfilling your sexual pleasure from your spouse. So you cannot treat a normal person having sex with a person of another gender on the same manner as compared to a husband having sex with a wife. They both are of different class, and Article 14 says that you can make different provisions for different classes of people. So that's why the government has defended it. And fifth, very importantly, government says that marriage is not an institution which can be created by outside. Marriage is rather a social institution, which means the society has created this marriage. So whatever the petitioners are saying that marital rape should be criminalized, these are the social things society has to deliberate. It is not up to the Supreme Court to step in and decide what should be the case. Rather, it is the wisdom of the society that should take the call. You can remember the same logic was used when the Supreme Court refused to allow same-sex marriages. Because again, marriage is an institution which is created by society, and hence society should deliberate. Who are the representatives of the society? It is the parliament. Hence, the parliament is the right forum to formulate such kind of policies related to marital rape. Other challenges related to marital rape are misuse of law and the burden of proof. How you're going to prove it? It's nearly impossible that woman has taken the husband has taken the consent or not. It is near to impossible, so it will lead to a lot of implementation challenges. Now, what does the petitioner says? Why does the petitioner says कि ये exception को हटा देना चाहिए? Marital rape should be considered as a rape. पहला चीज है deemed consent, which is based on patriarchy. Because in patriarchy, you know that there's one very important thing related to patriarchy is that woman does not have autonomy. Women are dependent on men. Woman does not have its own existence. Rather, woman's existence is derived from the men. That's why if a girl is marrying someone, then now there's no thing of consent. The girl has given the consent throughout her life to have sex with the husband. So that is known as the deemed consent. कि जब आपने शादी कर ही लिया है तो फिर consent क्यों लेना है? फिर तो है ही आपका मेरा. So that leads to perpetuates patriarchy because it denies the right of women to take decision about her sexual life. और जो existing laws हैं, जो गवर्नमेंट ने कहा कि existing laws हैं, वहां पे women जाके हेल्प ले सकती हैं, हस्बैंड के अगेंस्ट प्रोसीडिंग इनिशिएट करती हैं. बट प्रॉब्लम क्या है कि जो एग्जिस्टिंग लॉ है विच इज द डोमेस्टिक वायलेंस एक्ट, इसके अंदर केवल सिविल रेमेडीज प्रोवाइड किया गया है, विच मीन्स दैट इफ यू आर अ wife and husband has done this kind of thing, then the wife can initiate proceedings against the husband under the DVA, Domestic Violence Act. But the maximum recourse help which she can get is that she can get a divorce or she can get a compensation. Unlike rape, where you can get criminal remedies, where you can get that person arrested, even life imprisonment. But criminal proceedings cannot be initiated under the Domestic Violence Act. Only civil remedies, only civil proceedings. And what do you mean by civil proceedings? Civil proceedings मतलब आप उस person को जेल के अंदर नहीं डाल सकते हो. Yes, the girl can ask for compensation or the girl can maximum ask for divorce, but nothing more than that. लेकिन एक जजमेंट अगर आप बात करते कर्नाटका हाईकोर्ट की, जो बहुत रीसेंट 2022 में आया, तो कर्नाटका हाईकोर्ट की ये जज है जस्टिस एम नागा प्रसन्ना. इन्होंने एक बहुत ही लैंडमार्क जजमेंट दिया. एंड सी व्हाट ही सेज, अ मैन इज अ मैन, एन एक्ट इज एन एक्ट, अ रेप इज अ रेप. The age-old regressive thought that husbands are the rulers of their wife, their body, mind, and soul should be eliminated. So this judge has taken a very strong stand against marital rape. Although Karnataka High Court did not struck down this exception, उन्होंने कहा कि ये struck down करने का power Supreme Court का है. So I'm not striking this exception, but अगर यहां पे husband के against wife ने proceedings को initiate किया है, तो इसकी कार्रवाई कंटिन्यू होगी. So although the Karnataka High Court judge did not strike down, but in Karnataka High Court, still a case is going where a wife has initiated a rape proceeding against the husband because of this judge who has stood for women's right. What he says, a brutal act of sexual assault on the wife against her consent has to be a rape. कैसे आप इसको एक्सेप्शन कंसिडर कर सकते हैं? Such kind of incidents leads to have a great consequence on the mental balance of the wife. It affects her physiological and psychological impact. It scars the soul of the wives, and hence it is imperative for the lawmakers to hear the voices of the silence. Because women, आपको पता है, they do not speak. And hence it is the duty of the lawmaker, the government, the judiciary to hear to such kind of voices. So Karnataka High Court judge has given a very important judgment. Now, what are your views? आपके हिसाब से ये क्या सही है या क्या गलत है? क्या मैरिटल रेप को रेप कंसिडर करना चाहिए या मैरिटल रेप को एक्सेप्शन की तरह रखना चाहिए? इसके दोनों पर्सपेक्टिव है। आपके हिसाब से सही पर्सपेक्टिव क्या है? और आपको क्या लगता है कि इंडिया में ऑलरेडी रेप के बहुत सारे कानून हैं, तो क्या रेप रुक गया? नहीं, रेप में तो अब आपने लाइफ इंप्रिजनमेंट करके डेथ पनिशमेंट कर दिया है, बट स्टिल रेप केसेस बढ़ रहे हैं। मतलब लॉ हैज फेल्ड टू एक्ट एज अ डेटरेंट। लॉ से तो कुछ काम हो नहीं रहा है। सो व्हाट वी नीड इज नॉट, वी डोंट नीड लॉ, वी डोंट नीड मोर एक्सटर्नल थिंग्स, वी नीड इंटरनल रिफॉर्म्स। जब तक आप पैट्रियार्की को इंटरनली एक बच्चे के दिमाग से नहीं हटाओगे, तब तक जितने भी कानून ले आओ, कुछ भी कर लो, रेप, वायलेंस अगेंस्ट वुमेन नहीं खत्म होगा। और इंटरनल रिफॉर्म्स के लिए क्या करना पड़ेगा? क्वालिटी एजुकेशन पे फोकस होना होगा। लीडर्स को आने पड़ेंगे जो हमें इंस्पायर कर सके, और क्वालिटी ऑफ पेरेंटिंग वो भी, बिकॉज पेरेंट्स आर द रियल मॉडल्स। इसलिए ये तीनों का रोल बहुत ज्यादा जरूरी है। सो आपका क्या ओपिनियन है? प्लीज यू लेट मी नो। अगर आपको वीडियो अच्छा लगे तो लाइक करिएगा। सी यू अगेन इन द नेक्स्ट वीडियो। टिल देन गुड बाय, टेक केयर एंड बेस्ट विशेस।